Hi friends, today I would like to discuss with you one of the significant and important judgment of the Honorable Supreme Court of India. This is pertaining to the arbitration and it is connected with section 34 of the Arbitration and Conciliation Act. The name of the judgment is Perkins Eastman Judgment. It is also popularly known as Perkins Eastman Judgment. This judgment has been passed in the year of 2019 by the Honorable Supreme Court of India, wherein it was held that the appointment of arbitrator, if done unilaterally, then the proceeding of Arbitration and Conciliation Act, entire proceeding gets vitiated and award passed in such a proceeding by such arbitrator can be set aside or must be set aside and quashed. Therefore, the Honorable Supreme Court of India in this case has quashed and set aside the award passed by the arbitrator, as the under section 34 of the Arbitration and Conciliation Act, the proceeding can be filed to set aside the award in the district court or in the high court. Thereafter, as per section 37 of the Arbitration and Conciliation Act, arbitration appeal can be filed to challenge the order passed under section 34 of the Arbitration and Conciliation Act. Thereafter, the remedy lies before the Honorable Supreme Court of India. So this matter went to the Honorable Supreme Court, and it was held by the Honorable Supreme Court that the appointment of the arbitrator must be fair, reasonable, he should be independent and impartial. If the arbitrator has been appointed by one party only, that is unilateral appointment, in such a cases the appointment is not a fair, and in such a cases the arbitrator cannot be said to be an independent arbitrator or impartial arbitrator. In most of the cases, the bank appoints, financial institution or bank, they appoints the arbitrator from their own panel, who gets the fees from the such a financial institution or the bank, and he work as good as employee of that bank, and definitely he will pass the order in favor of that bank or financial institution only. Therefore, the independence of the arbitrator and impartiality, these 2 points were discussed, and specifically in the para 20 of this judgment, the Honorable Supreme Court has said that the appointment of the arbitrator must not be unilateral, it has to be bilateral, otherwise the entire proceeding gets vitiated, and that has to be quashed under section 34 of the Arbitration and Conciliation Act. Now we will also speak about something regarding section 34 of the Arbitration and Conciliation Act. We know that under section 34 of the Arbitration and Conciliation Act, petition can be filed in the district court or in the high court to set aside, praying for set aside the award passed by the arbitrator. In the commercial transaction every day, people wish to enter into agreements. They write a clause of arbitration in their agreements, or they make a separate arbitration agreement because they wish to invoke the proceeding of the Arbitration and Conciliation Act in case of any dispute or differences between the contracting parties. They never wish to go to the court because for filing civil suit or claiming damages or anything in the civil suit, that take much time. That is the drawback of the legal system in India. Except summary suit as provided under order 37 of the CPC, all the suit remaining gets much time, it consumes much time. Therefore, people do not wish that their time would be wasted in the court proceedings, so they wish to appoint arbitrator and they go for the arbitration, and they preferably they write a clause in the agreement, or they go for a separate agreement of Arbitration and Conciliation Act, so as to save the time of the court. Now, under section 34 of the Arbitration and Conciliation Act, there are some grounds on which the award passed by the arbitrator can be set aside. For example, the notice of appointment of arbitrator has not been duly served, properly served upon the other party, that is the applicant, or the proceeding has been initiated, arbitration proceeding has been initiated, such a notice regarding such a proceeding of arbitration has not been duly served upon the applicant, or the subject matter is not covered under the Arbitration and Conciliation Act, despite that the arbitration is invoked, or proper opportunity, fair opportunity of being heard is not given. So there are such kind of grants are available. So specifically, section 34 clause 3, that is 34C or 3, says that if the notice of appointment of arbitrator has not been served upon the applicant, or the notice of proceedings which has been initiated, arbitration proceeding, that notice of such a proceeding has not been duly served upon the applicant, in that case that award is liable to be set aside or quashed. Here in this case, this is the landmark judgment. I would like to put the same exact name of the judgment in the inbox. The name of the judgment is Perkins Eastman judgment. It is popularly known as a Perkins Eastman judgment, wherein once again I would like to reiterate that if the appointment of arbitrator has not been done bilaterally, it has been done unilaterally by only one party, then there is no fairness, there is no independence, there is no impartiality. Such a appointment is illegal against the settled judgment of the Supreme Court. Therefore, such a award passed by the arbitrator is liable to be quashed and set aside. So this is the landmark judgment which is still applicable as per Article 141 of the Constitution of India. The judgment delivered by the Supreme Court is binding on all the courts in India, throughout the country, including all high courts and lower courts. This judgment has not been reversed or stayed by the Honorable Supreme Court. It is still a landmark judgment, and in most of the cases, advocate they use this judgment throughout India. Even in my personal cases, even in my cases for on behalf of my client, I have used this citation and won many cases in Chennai, Calcutta, Mumbai, at Aurangabad bench also. So today I wanted to share this knowledge with you. I can also provide the copy of the judgment in the PDF form also if anyone wants this. Because the reason in this case that the bank most of the time they appoint the arbitrator from their own panel. Sometimes it happens that the arbitrator comes only for signature purpose only, and he doesn't see what is written here. Most of the time the employees of the bank they draft everything, notice of appointment, even award. Sometimes only arbitrator works like a rubber stamp only, just take the fees and sign the same. This happens, and most of the time arbitrator they pass the order in favor of the financial institution only, and they and suppress the borrower, because borrower who is in the need of the money, they takes the money. Suppose the people are taking money here in Maharashtra, the arbitration is invoked at Chennai, like a Cholamandalam, etc. Legally that is correct, but because if the arbitration agreement contains a clause that the proceeding can be initiated at Chennai, so it will be within the purview of law. They can invoke the proceeding at Chennai, but that will be harassment to a petitioner who is staying in Maharashtra. Bank has branch in Maharashtra, but to challenge the award proceeding of arbitration and conciliation is conducted at Chennai, and to challenge that such award, the party has to go to the Chennai. Therefore, this judgment is very significant. Keep in mind, please remember this judgment. The name of the judgment is Perkins Eastman versus HD CC India Limited. I'll be giving the exact name of this judgment citation in the inbox. Thanks for hearing to me, Advocate Shahid Ali Ansari, a practicing advocate at High Court of Bombay.